We all know business is competitive, right? It can be absolutely cutthroat out there. But even in a fierce competition, there are rules. There are legal lines that you just don't cross. Today, we're diving into what happens when business gets a little too personal, exploring the world of economic torts. I want you to picture this for a second. You are this close to landing the biggest deal of your career. The contracts are practically signed, and then poof, it's gone. The client just backs out. Later, you find out a competitor was whispering in their ear. So, was that just bad luck, or did they do something illegal? That's exactly the kind of question these laws are meant to answer. You know, when most of us think about what the law protects, we think about our physical safety, our property, our land, but the legal system's protection goes way beyond that. It also guards our financial well-being and our business relationships. And that's where we get into the world of torts. So, what in the world is a tort? Well, let's break it down. At its core, it's a civil wrong. It's when somebody's action, or sometimes their inaction, causes harm to someone else, and the courts can step in and hold them accountable. This isn't just about a broken contract, it's about any wrongful act that leads to some kind of injury. Okay, so this really helps put it in perspective. Think of it like two sides of the same coin. We're all pretty familiar with torts that protect us physically, right? Like battery. Well, economic torts do the exact same thing, but for our financial health. They protect our contracts, our business relationships, and even the deals we're hoping to make in the future. All right, let's start with the most clear-cut example. Someone intentionally messing with a deal that you already have locked down. This is called intentional interference with a contract. The key idea here is that once a contract is signed, it's like a protected space. The law basically says that a third party, someone outside the deal, can't just come in with a wrecking ball and try to blow it up for their own benefit. If they do, there are going to be consequences. Now, if you think this has happened to you, you can't just say it. You have to prove it. And there are 5 key things you've got to show. Let's use an example. Say you have a contract to supply widgets to company A. First, that contract has to be real and valid. Second, your competitor, company B, had to know about it. They can't accidentally interfere. Third, they had to intend to interfere. Maybe they started spreading false rumors about your widgets. Fourth, what they did actually had to cause company A to break the contract. And finally, you have to show that you lost money because of it. Okay, so that covers deals that are signed, sealed, and delivered. But what about all the potential deals? You know, the handshakes, the promising negotiations, the leads you're actively chasing. Does the law protect those too? Yep, it does. And this is where things get even more interesting. This one's a bit of a mouthful, interference with prospective economic advantage. But the idea behind it is actually pretty simple. It protects your reasonable expectation of future business even before you've got a contract signed on the dotted line. The checklist here looks pretty similar to the last one, but there is one absolutely critical difference. See that phrase, intentional and wrongful acts? That word, wrongful, is everything. Since there's no solid contract yet, a competitor's actions have to be improper in some way. We're talking about things like fraud, defamation, or threats. Just offering a better price? That's usually not going to be enough to be considered wrongful. All right, now let's shift gears and look inside the contract itself, because it turns out there's an unwritten rule, a sort of legal gentleman's agreement that is a part of every single contract. And this is it, the covenant of good faith and fair dealing. It's this implied promise that says, hey, we're in this together. You can't do sneaky, underhanded things to stop me from getting the benefit of the deal we made. It's not usually written down in the contract, but the courts act as if it's there. It's all about fair play. So why does this matter so much? Well, it all comes down to the money, the remedies. If someone violates this unspoken promise in a really bad way, it might not just be a breach of contract. It could be a tort. And the damages are worlds apart. For a contract breach, you might just get the value of the deal back. But for a bad faith tort claim, you could get punitive damages. That's extra money awarded specifically to punish the wrongdoer. It is a much, much more powerful legal tool. So all of this leads us to the big million-dollar question. How do we actually tell the difference between just good, healthy, aggressive competition and illegal sabotage? Exactly. That's what you might be thinking. I mean, the market is supposed to be competitive. The law actually encourages it. So where does the court finally draw the line and say, okay, you've officially gone too far? Well, the law is pretty clear that some interference is totally okay. The key word here is justification. The law recognizes that fair competition, like just offering a better deal or a better product, is almost always a legitimate, justified reason to win a customer over. The point isn't to stop competition, it's to stop people from playing dirty. The thing is, there's no simple formula here. A court doesn't just check a box. Instead, they look at the whole picture. They consider all these factors. What did the person actually do? Why did they do it? Was it for a legitimate business reason, or was it just pure malice? What are the bigger social interests at stake? It's a really complex balancing act. So, after going through all these legal ideas, what's the fundamental principle here? What's the main thing we should really walk away with? It really boils down to this. Our whole economy is built on competition. But that competition needs a rulebook. It needs rules for fair play so that things don't just fall into chaos. And these economic torts, they're a huge part of that rulebook. And that is the crucial takeaway. The law sees your contracts and your potential business deals as valuable assets, and it gives you a way to protect those assets from people who are trying to intentionally and unfairly tear them down. It's all about creating some stability and predictability in the marketplace. And that really leaves us with one final big question for today. In our modern economy, full of startups and disruptive technologies, these lines can get really blurry. When does a new company that completely upends an industry cross that line from being a brilliant innovator to being an illegal interferer? That's a huge question that our courts and really all of us are going to be wrestling with for years to come.